Joe Greathouse on your docket.
Mr. Greathouse, come up.
Judge, you told him not to drive. The allegation is that he was.
This case isn't what it looks like, and it starts with a contradiction that could flip everything. The defendant's accused of driving on a suspended license. But here's the twist. That suspension might not have even existed. The defense comes out swinging, dropping a dismissed ALR order like it's a royal flush. So why did the judge tell him not to drive? Was it just a legal mix-up or something bigger? And buckle up, because the courtroom drama is just heating up. What would you do if pre-trial said go, but the judge said no?
Was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
No, okay.
There was never a suspension on his license at all. He's been good to drive.
He was also drinking. But the concern was that he was drinking.
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
He was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, this should be eligible to.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response that when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on the license. It's the IC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
And does he have an interlock as well?
Yes, Judge, he has interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, does it.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask.
Hold up. That wasn't just drama. That was a judicial mic drop. I don't care who told him. That line came after a fiery debate about whether pretrial services could override a court order. Spoiler alert, they can't. In Texas, a court order is binding until it's officially overturned, no matter who else says different. This was the breaking point where confusion ran straight into legal reality. The defense tried to lean on implied permission, but the judge's patience was gone. Would you risk driving if pretrial cleared you, or wait for the court's green light?
Ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you
It
don't.
doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
It was a suspension
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on.
4/2, Your Honor.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order, Mr. Jurisich? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
The
you.
order suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
Yeah, 12/6/2024, end
Herrera?
date 6/3/2025, and the lift date comes in at
And
And then if that's,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what I can see.
if there's a dismissal order,
In the end, the defendant walks, but just barely. Turns out he was legally allowed to drive, but only by the thinnest thread of paperwork. One missing document, and he'd have been sitting in jail. This case was a wild ride through legal gray areas, courtroom sparks, and a judge ready to lay down the hammer. If your jaw's on the floor, smash that like button, drop your verdict in the comments, and subscribe for courtroom drama stranger than fiction.
then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court order.
I understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pre-trial, not anyone else. Do you understand?
Sir.
All right.
And here's where it all comes apart. The defense brings the receipts, a dismissal order proving the suspension never legally existed. But here's the catch. The judge only sees what DPS shows on their system. That means the defendant got held to a court order based on old or bad info. So ask yourself, if the order came from a legal ghost, does it even hold weight? This is where law and logistics collide, and one false record almost landed someone in jail. Makes you wonder how many court orders out there are built on broken data.
Good luck, sir.
Thank you, Judge.
Good luck with your appointment, Mr. Johnson.
Thank you, Judge.